your punishment range becomes a second-degree felony, which means you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Plus, you would not be eligible for probation in front of a jury if
Yes,
this
sir.
prior conviction. You going to interrupt me? Yeah, let's follow the rules for a change. That's why you're here. We all follow, and we all have to follow the rules.
Strap in, folks, because what you're about to witness isn't your typical Bond hearing. It's chaos straight out of a crime thriller. Picture this: an 18-year-old defendant, armed with an AR-15 style rifle, accused of spraying bullets into an apartment complex in broad daylight. 2 people shot, cars riddled with holes, and bullets punching through walls where families were supposed to feel safe. And yet, here we are, arguing about whether his $150,000 bond should be reduced. But that's just the surface. In this hearing, you'll see defense lawyers pleading for leniency, judges fed up with repeated violence, and the shocking criminal history that flips the case upside down. The stakes? A potential decades-long prison sentence. The drama? Off the charts. Stay tuned, because this courtroom showdown is about to expose whether justice bends or stands firm.
All right, this states that the defendant, probable cause affidavit I'm referring to in the file here. And that the defendant and another person fired multiple rifle rounds into an apartment complex parking lot, resulting in 2 people sustaining gunshot wounds. And multiple apartments, occupied and unoccupied, were struck by gunfire, as well as multiple vehicles were hit. And according to the surveillance footage here, AR-15 style rifles were used in the commission of this offense and this shooting. Montreal Lightfoot is identified as one of the persons involved in the firing of the weapons. What is his bond now? Are you asking for a reduction in bond?
Yeah.
What is his bond right now? Mr. Burbank, you're asking for a reduction in bond, and the bond is $150,000. Is that what it is?
Yes.
Go ahead.
I can put him on if you want.
What do you want to do? Whatever you want.
We're asking for a reduction to 50,000.
What do you want to do? Do you want to put him on?
I can put him on if you need to.
I don't need to, whatever you
I
want.
can shortcut it.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing, sir, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And please state your full name.
Montreal Lightfoot.
Okay, and your date of birth is September 29th, 2006, correct? You have to speak out.
Yes, sir.
Okay. Yes, everything. Yeah, you nod and shake your head.
Right here, the defense makes their move, asking to slash bond from $150,000 down to just $50,000. Think about that. 2 people shot, apartments ripped apart by bullets, cars destroyed, and the request is essentially a bargain bin price for freedom. This is a classic defense tactic. Argue that the defendant is young, has no money, and should be given a second chance at home with mom. But here's the catch: bond isn't about what you can afford. It's about ensuring public safety and guaranteeing you show up for trial. With an AR-15 style shooting on the record, is $50,000 really enough to protect the community? What do you think? Should ability to pay outweigh public safety? Comment below.
It doesn't work. She's got to take everything down so that we can have it for a record. Go ahead, Mr. Burbank.
Dr. Al, how old are you?
18.
18. And do you have any bank accounts or any money that you could possibly post a $150,000 bond?
No, sir.
Do you have any vehicles? Do you have any property that you could put up as collateral for a bond?
No, sir.
Prior to being incarcerated, well, how long have you been in jail?
4.5 minutes.
4.5 months. And before that time, were you a resident of Beaumont?
Mm-hmm.
And who were you living with?
My mom.
And your mom. And if you were to be able to post bond and get out, would you go back with your mom?
Yes, sir.
Where does she live?
Straightaway.
Straightaway? Okay, and she has a place for you to stay, correct?
Yes,
You
sir.
can get rid of your bed, huh?
Yes, sir.
If you were to get out too, you would abide by all the rules and conditions.
Yes, sir.
One might be a GPS. They want to know where you're at.
Yes, sir.
Would you be able to do that?
Yes, sir.
There may be a curfew saying that you can't go out all hours of the night. Would you be able to do that?
Yes, sir.
And you're asking for a bond reduction at this time?
Yes, sir.
We're asking your honor that it be reduced down to 50,000.
State. Any questions?
Did you graduate from high school, sir?
No, sir.
Are my records accurate that you've not been arrested before?
No, not university.
Never had any juvenile history either, is that correct?
No.
Those are my only questions, Jeff.
Notice how the defendant paints himself as squeaky clean, claiming no arrests, no juvenile record, nothing. But watch carefully, because within minutes, the prosecution flips that story on its head. This is a tactic we see often in court: minimize your past, hope the judge only looks at today's charge. But when your rap sheet is pages long, the truth is bound to surface. This moment sets up a dramatic contradiction, one that the judge won't ignore.
The court is looking at the public safety report, as courts are required to do on taking issues of bond. I'm looking at this report. The defendant, among other things, it discusses the charge here in this indictment 25 CR 715, deadly conduct, discharge of a firearm. And it also states the defendant was in July of 23 evading arrest or detention, a Class A misdemeanor, was referred I guess juvenile disposition. May 26, 2023, illegal possession of a dangerous drug, a Class A misdemeanor, that was referred. On November 15th, 2021, state jail felony of unauthorized use of a motor vehicle, that was adjudicated, and the defendant was placed on 1-year probation. And on November 15th, 2021, also an evading arrest with detention, a 3rd-degree felony, adjudicated, placed on probation with the unauthorized use of a motor vehicle for 1 year. That's what this is. That true?
Yes, sir.
Okay, that's not what you told him.
And here it is, the reveal. The defendant's record isn't spotless, it's riddled with priors. Evading arrest, drug possession, unauthorized use of a motor vehicle, the list goes on. Even probation in the past. This is why judges dig into public safety reports. They tell the real story, not the polished version from the defense table. The irony? He just denied having any record minutes ago. That kind of credibility hit in front of a judge? Deadly to your case.
Yeah.
I believe he was talking about his adult side.
Whatever.
No, I asked specifically
That's not
about
what he
attorneys.
asked. He asked for anything. It was a global question. But the point is that the public safety report is made a part of the record in this, for this hearing, and sealed otherwise, because this is going to be dealing with some juvenile behavior. So this isn't the first time you've been arrested, is what this says. And this isn't the first time you've been before a court and a proceeding for criminal matters. So you know how it is. You know that actions have consequences. Good actions are bad, have bad consequences. Here, the court is looking at the probable cause affidavit, where there are numerous assault rifle rounds fired in a multi-family dwelling apartment complex here in this city at looks like about noontime. And you and another person were apparently identified as being the or among the people involved in the firing of those weapons. And the two people were shot, multiple apartments struck by gunfire, and multiple vehicles hit. In this city, this is like a bad movie. We're not going to put up with obnoxious, bizarre, violent, random behavior where people in an apartment complex, you have all sorts of people from young to old, where you have bullets flying around. This is absurd behavior in a life that we've had enough of violence. We don't want irresponsible behavior, and we certainly don't want people shot or in harm's way. And we don't want an environment where in the middle of the day, there are assault weapons being fired among the homes, multifamily dwellings in this city.
This is where the judge takes the gloves off. He compares the shooting to a bad movie, and he's not wrong. Random gunfire in the middle of the day, children and families ducking for cover, 2 people shot. The message is clear. The courtroom is drawing a line in the sand. Judges don't just punish the act, they send a message to the entire community: we won't tolerate chaos. And honestly, can you blame him? Just one stray bullet could have turned this into a mass casualty tragedy. What do you think? Was the judge too harsh, or was this exactly what needed to be said?
We won't tolerate it. And you know from your previous criminal involvement with the crimes of evading arrest, illegal possession of drugs, unauthorized use of a motor vehicle, evading arrests, those all have consequences. And you were placed on a form of probation, it looks like juvenile, so you know that this is serious. But it's the law. We're supposed to live peaceably in this country, much less this city. And it's what we make of it. We are not going to tolerate wild behavior like this, where people are in harm's way. It only takes one bullet to kill someone. Your bond is, if it were me, I'd raise it. I don't tolerate this. The people in the city don't want chaos, especially someone who's been through this criminal system before. Shame on you. So the bond is not dismissed, it is not reduced. If he posts a bond, if you post a bond, you must have a GPS device. You will be at home confinement. You will not leave your home except for necessary reasons and with the court's prior permission. Any reason, I want to have know what it is, and I'm going to be the determiner whether you're going to be allowed to leave the home or not. But this is chaos, and the people don't tolerate this. No civilized group would ever tolerate this. Shame on and anybody else who pulls stunts like this. How many rounds were recovered?
That's a good question, Judge.
Numerous?
It was a lot. I
Yeah,
remember
only
that.
takes, that's one for each soul who was at risk.
One of
Could
the
have
things-
killed a whole bunch of people.
It sent 2 different people to the hospital, Judge.
Killed them.
But I don't
But people's homes and vehicles were damaged. Chaos. That's not tolerated. Shame on you. And anybody else involved with that. Shame on you.
The defense was hoping for mercy, but here's the reality check: bond reduction denied. The $150,000 stands. And even if somehow posted, the judge tacks on GPS monitoring and home confinement. Translation? This defendant wouldn't be going anywhere without a digital leash. That's how serious the court views this case. Judges often weigh risk versus rights in bond hearings, and here, the scale tipped heavy on risk. And let's be real, would you want this young man, accused of spraying bullets into apartments, walking free on your block?
So, no,
Thank
you can
Judge.
sit in custody until we get this thing finished.
I'd ask that we place on the trial.
It's set for trial.
Move this on,
Sure.
Judge.
Sure. Let's set for trial and get it fast tracked. I want a jury in to hear this and to decide his fate as soon as possible.
One other thing for your honor's education, in this young man's 130 days in the jail, he's had 9 what they label criminal incidents. So his behavior in the jail is not,
What am I supposed to do?
I'm just educating the court that you're certainly made the absolute right decision based upon his behavior in pending custody, Judge.
Okay. But it's based, I didn't know that information,
Yes, sir.
but I guess I'm not surprised based upon the public safety report, the criminal history, and the probable cause affidavit. You're free falling. You don't care about anybody else. The others, your creator should be first, other people second, and then you third. That's what all humans should be. We should be selfless, not carrying around weapons that can kill anybody and erratically firing those in multifamily dwellings and at cars. The fact that there weren't 20 or 30 people killed here by you, I guess, is a miracle. But it wasn't because of your brilliant thinking. It's just God's will prevented that from happening. But we are going to step in and control you as best we can. Everybody has free choice, and your choices are poor. Anything else? That's
Not from the state. Thank you, Judge.
all right. Cavante Willis. This alleges in paragraph 1 that on or about May 5th, 2025 in Jefferson County, Texas, he committed the 3rd-degree felony of deadly conduct by discharging a firearm at or in the direction of others. And then paragraph 2 goes on to allege that you have been convicted out of Lafayette Parish, Louisiana in 2021 for robbery. So if you are found guilty.
And just when you think this courtroom storm is passing, bam, another defendant enters, Cavante Willis, only 22, facing nearly identical charges. But here's the kicker, he's got a robbery conviction on his record. That prior ups the stakes dramatically. With it, probation isn't even an option. He's staring down up to 30 years in prison if convicted. You can almost feel the weight of the judge's words as he lays out the math. No less than 2, no more than 20 years. The question isn't just guilt, it's survival. Do you think young defendants like Willis can ever turn it around, or are they locked into this cycle for life?
Of this 3rd-degree felony of deadly conduct, and this prior conviction was indeed deemed valid and admitted at a hearing, your punishment range becomes a 2nd-degree felony, which means you were looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Plus, you would not be eligible for probation in front of a jury if
Yes,
this
sir.
prior conviction. You going to interrupt me? Yeah, let's follow the rules for a change. That's why you're here. We all follow, and we all have to follow the rules. But you get in trouble when you don't. And finally, in 25 CR 717, in this case, you are indicted with the 3rd-degree felony of unlawful possession of a firearm by a previously convicted felon. So totally, you're looking at up to 30 years confinement is what you're exposed to. And in this deadly conduct, whatever sentence you get, it would not be paroled until you served 1/2 of your sentence on this deadly conduct. So if you receive a 20-year sentence, you won't see light of day in the free world until you've served at least 10 years confinement in prison. And you're not eligible for probation. So you've gotten yourself into a box here. You got to deal with it responsibly. She's a fine lawyer. I'd follow her advice if I were you. Do you understand what you're charged with and what the punishment range is here in each of these cases? Why are we here? It's a hearing on what?
Bail reduction.
What is his violence?
Just on the deadly conduct, it's $50,000.
I'm sorry, it's one.
$50,000, and on the unlawful possession of a firearm, it's $100,000.
Mr. Willis, will you tell us how old you are
22 years old.
and how old were you at the time of the incident?
This incident already,
Yes.
I'm 22.
Okay.
I wasn't here with this incident, so
Okay, do you have any current bank accounts or cash on hand that you could use to help pay this bond?
yes, ma'am.
How much do you have available?
I don't know. This is my daughter bank account.
Do you have the funds available to pay
Yes, my mom should have.
the entire $150,000?
Not the entire 150,000.
Okay. Do you have any property that you could use for collateral to pay the entire $150,000?
So
All right. Who were you living with before?
my mother.
And if you were to be released on bond, if you were able to pay your bond,
This is the hammer drop for Willis. The judge isn't just reading off charges, he's building a narrative of someone who keeps escalating. Unauthorized vehicle use, probation violations, and now a shooting case. What makes this moment brutal is the legal reality. Once you stack a robbery conviction on top of this, the options narrow fast. No probation, no easy out. The courtroom energy shifts here. You can almost see Willis shrinking in his chair as the consequences pile up. And this is where defendants often realize, bond hearings aren't about sympathy, they're about cold, hard history. Would you trust someone with this record to walk free until trial?
who would you go to live with?
My mother.
And she would still want you to live with her?
Yes, ma'am.
And she resides in Jefferson County?
Yes, ma'am.
Okay. And if you are released or able to pay the bond, you understand that that may come with some conditions?
Yes, ma'am.
Conditions that might include you to wear an ankle monitor,
Yes, ma'am.
conditions that might require you to be homebound.
Yes, ma'am.
Okay, and you're prepared to follow any of those terms and conditions?
Yes, ma'am.
All right. Judge, we are asking for a reduction in bond down to $50,000.
And she had asked you a question. I just want to make sure that we all think about this real hard. She asked you, and you can follow all conditions that a court would set.
Yes, sir.
There's not a doubt about
No doubt about
May I?
it. So help you God.
it. Can I say something real quick?
Yes, sir.
See, I was already on probation before, but I had completed my probation. Why am I not eligible for probation again?
I'll talk to you about that after this hearing, if that's okay, Judge.
Okay,
May I ask questions?
go ahead.
You are Cavante Willis,
Yes, sir.
spelling Kevontay.
Yes, sir.
Your date of birth is December 4th, 2002.
Yes, sir.
You were convicted in the Lafayette Parish in Louisiana on August 26, 2021
Yes, sir.
for the offense of simple robbery
Yes, sir.
in cause number CR-179579 in the 15th Judicial District Court located there.
Yes, sir.
Yes, sir.
And on that, you received for that offense, you did receive looks like the equivalent of some kind of probation where you were sentenced for 3 years, but hard labor, but it was probated for 3 years.
Yes, sir.
You were just referencing to the court that you had finished that probation.
Yes, sir.
When did you finish the probation?
I finished in 2024 around March.
Okay, go ahead.
Show you a picture that's in there. Is that individual you?
Yes, sir.
So you're not disputing the fact that you've been convicted before of simple robbery from that
Yes, sir.
deal that we've been talking about. All right, so let's talk about your conduct in jail. My records indicate that you have been in custody for 129 days, true?
Yes, sir.
My records indicate that you have been reported for different incidents of not following the rules starting in June 11th of 2025. all the way up until right before you appeared here in court on the date of September 21st, 2025, yesterday.
Yes, sir.
You want to modify your answer to that you gave the judge that you have the ability to follow rules?
Yes, sir. See, most of the cases I got in fights, but like I got jumped and all them situations, like when it was my fault. Just I'm not from around here, so just I don't know how to explain it. But
I don't have any other questions along those lines, Judge.
Okay.
Anything else would be about the offense. and I'm
Let
not
me
gonna
ask you
go
about the
there.
probation that you were previously on. How did that get disposed of?
You completed the terms of that
Yeah.
probation,
I
correct?
completed the probation.
Or,
This part is almost painful. Willis claims he can follow rules if released, but his jail record shows the opposite. 9 incidents in just 129 days. Fighting, breaking rules, constant disruptions. And what's his excuse? He says he's not from around here and got jumped. Here's the legal problem. Judges don't weigh excuses, they weigh patterns. And the pattern screams chaos. If you can't follow the rules in jail, how can the court trust you to follow them outside with an ankle monitor? This is the ultimate credibility test, and Willis is failing miserably.
for 3 years? It was a 3-year term of
Yes, sir.
probation?
It was a 3 and 7 if I violated. 3
Was it,
years.
was it February of 21?
Yes, sir.
No, that's the arrest date.
I believe
When-
that.
when were you placed on
conviction date
probation?
was
I'm
August
sorry.
August, yeah,
21,
August of 21.
August of 21, which means he's been a little over 4 years
But when did he get off of, when was he released from probation?
last year.
In 24.
24. yes, sir.
The actual notes in our record says he was released unsatisfactory. That's from the custodian of the records for the pin packet that
Yeah, I'm
was
not sure
received
what
and
that
uploaded.
exactly means. That's, doesn't sound good, but I don't know what it means, really.
And in fairness to all of us, Your Honor, I also don't know what that means. From his understanding, he completed the probation. He didn't get any further.
Sentence?
Yes, so
So it ended with a probation, but it's a regular probation. He was found guilty,
Yes,
Yes.
sir.
not deferred.
It was a regular-
You were
regular
found
probation.
guilty beyond a reasonable doubt. That probation was not dismissed, though, and exonerate, he wasn't.
Correct.
it-
It's our equivalent of a straight, it's our equivalent of a straight
So
probation, yes, sir.
So you have, and that's why this is alleged here as a prior conviction in paragraph 2, which they're going to argue at trial feasibly that you're not eligible for probation because of this, if it's proven true beyond a reasonable doubt, and that the punishment range is enhanced. It's higher because of that.
And it's that conviction the state is relying on for him to be a felon in possession of firearm, Judge.
and just for judge's clarification, what age were you at the time of that conviction?
17.
17 at the age of that conviction, Judge.
Did you know better?
Yes, sir.
What?
At the time, I know better.
I was 17 months. I know better than
Yes, I know
to
better
commit
now.
robberies.
Yes,
I mean,
sir.
how old do you have to be to know that a violent crime is real? All right, I have the public safety report as well. All right, you're asking Ms. Naraj for,
Yes, Your Honor, we're asking for a reduction in that amount to 50,000, something that is potentially capable for him to pay.
understand. The court has also reviewed the probable cause affidavit in this case. And again, this is a most aggravated, serious case where multiple rounds of AR-15 style rifles were fired into vehicles and apartments, units of a multi-dwelling apartment complex in this city of Beaumont, Jefferson County, Texas. And 7.62 and 5.56 caliber rounds connected to assault style weapons were fired in this case, and the current bond, the court feels is proper based upon the circumstances of this case and the defendant's criminal history. And shame on anyone who is so irresponsible to fire assault weapons at midday into apartment units and vehicles at a multi-family dwelling facility like this apartment complex here in Beaumont. Your bond is not reduced. If you can post the bond in this case, you will be placed on home confinement. You must have a GPS device. You cannot leave your residence under those circumstances unless a permission is granted ahead of time by this court. Do you understand
Yes.
where you are? And this is all due to the circumstances of this crime and your criminal history. Anything else?
Yeah.
That is all. Thank you.
I have a question.
Yeah, you can talk to her.
So, let's tie this all together. 2 defendants, 2 bond hearings, both tied to the same midday apartment complex shooting, both begging for bond reductions, and both denied. The judge sent a crystal clear message. Public safety comes first, leniency second. Montreal Lightfoot, bond stays at $150,000, GPS and homebound if somehow posted. Kevin T. Willis, same deal, but with a robbery conviction that guarantees no jury probation. In both cases, the courtroom refused to bend. And honestly, this wasn't just about these 2 men. This was about reminding the community that random gunfire in neighborhoods won't be tolerated. What do you think? Was justice served, or was the judge too unforgiving? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.